can't tell if he's in the room yet, but he should be here momentarily. If I have a suggestion, though, that I have a strong suspicion that Summit is going to have an objection to the presentation of Mr. Bonner as a witness. And if they do, perhaps we can get that out of the way. No objection? Oh, well, in that case, I apologize. I do know he is on his way and should be here within a few minutes.
Do you know how to sing or have any songs for us? Or?
Oh, you really don't want to hear my singing.
Well, for the sake of just keeping things moving along, Mr. Jorde, because we can always come back to you, Miss Ryan. So,
yeah, thank you.
Mr. Jorde, we'll just go ahead and get started with your first witness, which I have on my list as Julie, my apologies, Julie Glade.
Yes, that's correct.
Okay, so if you'd like to call your first witness.
Be great. Julie Glade, please.
Good morning, Ms. Glade. If you could please raise your right hand for me. And do you swear or affirm the testimony you are about to provide is true and accurate?
I do.
All right, thank you. Mr. Jorde?
Yes, good morning, ma'am. Can you state your name, please?
Julie Glade.
And what county are you a landowner in?
I am in Wright County.
All right, very good. And, ma'am, did you prepare and cause to be filed in this action pre-filed testimony as well as exhibits in the form of attachments with that testimony?
I did.
And if we were to walk through all of those questions, would your answers be substantially the same as they were when you pre-filed that testimony?
Yes, they would.
And do you have any corrections that you'd like to make at this time to the testimony?
Well, I do. In my pre-filed testimony, I stated that our son and his family were planning to move to our farm in Wright County. This is a farm that I grew up in. It's just south of Clarion. And this farm is actually, we estimate to be only 600 feet from Summit's proposed carbon pipeline. And I'm kind of wondering if we can take a look at the KMZ on that for our acreage. We're estimating that. We're not sure if that's correct, and I hate to misspeak.
Objection.
State your objection.
What's the correction to the direct testimony? This is a time to make corrections to typographical errors, not to add to the direct testimony.
Mr. Jorde?
Well, she hasn't finished the update or the correction yet, but there's also under 7.10 sub 2, the witness may be permitted to correct or update pre-filed testimony on the stand. And so whether this is a quote-unquote correction, which it sounds like it is, or an update, I think it's allowable under the rules.
So, Mr. Leonard, anything further?
I think update refers to a temporal update. If this is just extra information, that's not updating what was listed in the direct testimony.
Can you tie this into your direct testimony and provide us?
I'm just kind of laying the foundation of what changed in my pre-filed testimony since I filed it.
So we're going to proceed with it, but I need more information for our staff back here so we know the page number of what you're referencing, so we know where this correction is being made.
I'd have to see my testimony, because I don't know what page number it's on. I don't have it in front of me. As I stated, my son and his family were planning on moving to this farm, and after they have seen
and listened to us. They've been finding out more and more about the hazardous nature of this pipeline, how dangerous it would be to live at this farm. They've put their plans on hold, and they're not going ahead with moving at this point. They're waiting to see what the outcome of this hearing is. And it's very important to our family. This has been devastating to our family. And that's...
Yep, and I think they've just located that last sentence there that's on the screen. Do you see that?
Can you scroll up, please,
Right.
Grace, and just... What page is this on?
Page 3, it looks like.
All right, so page 3 of the direct testimony,
Yes,
just for the record.
correct.
Okay, thank you.
All right, ma'am. So you're on the screen there. There's an answer that's about a paragraph or so long there. It looks like is that the last sentence of that paragraph that you want to correct.
That's correct.
All right, and what's the correction?
Our son and his family have put on hold their plans of moving to the acreage until they find out the outcome of this hearing. I don't think, I've seen more and more about the safety issues that this pipeline poses, and I don't wish anyone to live next to a pipeline. 600 feet is what we estimate that our farm is away from this pipeline. We have been to PHMSA meetings in Des Moines. We've heard from the survivor.
State your objection.
I believe the correction to the testimony has been made. This is now further direct testimony.
Mr. Jorde?
I think we got that correction, ma'am. And then was there a second one on the 600 feet? Do we need to measure it to correct the 600-foot estimate you provided?
Yes, I would like that, please.
May it be heard?
Yes, you may.
Is the 600-foot estimate in the direct testimony?
It is. It's on the bottom of page 4.
Can we go to page 4, please? All right. Could staff please get that distance? We'll make the correction. Then we're going to move on.
And will this be clear? Which is the home? It's the northernmost building?
I need to see it a little closer. I believe so.
Okay.
Yes.
Looks like 650 approximately.
Yes.
Yes.
650 feet.
Okay, so to be precise, you'd like to change that from 600 to 650 feet?
Yes.
All right, very good. Was there any other corrections to be made?
No other corrections.
All right, very good. We will offer exhibits, landowner exhibits 454 through 462, which will be the written testimony along with the exhibits to that testimony of Ms. Glade.
Thank you.
Just for clarification, they're the attachments to the pre-filed testimony.
Correct.
Thank you, Mr. Jorde. No objection.
All right. Thank you.
All right. With that, I will tender the witness for cross.
We're going to admit that as well. Are there any objections?
I'm sorry, I thought Mr. Leonard did.
No objection.
All right. So they are admitted. Thank you.
Thank you. I will tender the witness for cross-examination.
I believe, Miss Ryan, you were the first up, so you're the first to go.
Thank you. Good morning, Ms. Glade.
Good morning.
You said that your son has changed his plans since you filed your testimony.
Yes.
Do you feel like during the negotiation process, Summit gave you adequate information to understand the safety risks of having this pipeline on your property?
No, they did not. I've been to many meetings, Board of Supervisors meetings in Wright County. We've asked for plume studies. We've asked for information at that meeting. And we were told that they couldn't disclose their plume studies. At that meeting, there was a lot of questions asked them. They were very evasive. And actually, Rod Dillon was on Zoom at that meeting, and he stated at that meeting, and I want to read this because I want to be on the record. I want people to know what he said. He stated that at 100 feet from a rupture, that would be critical to human safety. Out to 300 feet it is borderline, and at 300 feet there should be no risk. And I thought 300 feet, when we knew, everyone knows what happened in Satarsha. There were people found just a half a mile from that rupture that were on the brink of death. That's what the witness said here at these hearings. And Rod Dillon is telling us 300 feet. I had to go back and listen to that Board of Supervisors meeting again because I thought, well, maybe he had meant yards. He said feet. And it just seems to me to be a blatant lie. Can't really put it much differently than that. We've also seen the test rupture in the UK. We've seen how far that plume can travel. At 600 feet from a pipeline, if a rupture would happen near our farm, we're in the dead zone. We have minutes to get to safety. And my family, I'm not willing to put my family in that kind of risk. I'd love to have them live in the farm. It just is heartbreaking to me that they have to worry about living in a place where I grew up, where they want to go. They want to have horses, and they want to be outside with their dogs, and when we have to talk to them about what they would do in case of a rupture, we talk about sheltering in place, and would they even be able to get to the house in 2 minutes if they're out riding horses? They're not going to survive something like that. It's bound to happen. It's going to happen. These are man-made pipelines. And it's just, I really resent the fact that Summit is taking away what should be some of the happiest times of our lives when they're going to be moving. And I don't know if that's going to happen now. Also at this meeting, another misrepresentation. It just seems like Summit is so willing to misrepresent and bully the landowners into signing easements. At the same meeting, Grant Terry told us that if you didn't negotiate, these are his words, if you don't negotiate with us, then we won't know where your tile lines lie, insinuating that we don't really care about your tile lines. Or they're just trying to bully people into signing lease agreements.
And you mentioned other activities that your son and his family do on your property. Do you think that having a pipeline on your property would also prevent them from doing things like coming and going horse riding with you?
They would certainly be more aware, more afraid of I'm not sure if they're going to want to even live there. I mean, they're both first responders. They understand the risk, and we talk about sheltering in place. And it would definitely just kind of be in the back of your minds constantly, knowing that that's there. We talk about sheltering in place. Do they need to, there's an upstairs dorm or bedroom, do they all need to go to bed upstairs in case a rupture would happen at night? How do you know you're going to wake up in the morning when you have that hanging over? It just would be constantly in the back of your mind that there's a threat there, and this pipeline can kill people. And that's why we don't want to negotiate. I'm not going to negotiate with something that can kill someone. And we've seen that in Satarsha. We've heard their witnesses. And for them to downplay the safety aspect of this is just wrong.
And you live in the house that's approximately 600 feet.
We don't live there now, no.
Okay. Does anybody live there now?
No, it's been vacant since my father passed away 7 years ago. We live in Cedar Falls. So we're just really thrilled that someone was going to want to live there.
So you'll basically be left with an empty house as a result of this.
We could, yes. Yes.
Do you think you would be able to rent it out?
I don't think I'd want to rent it to anyone there. It's too close. And I don't think if the pipeline would go through, we would probably put that land in CRP. We aren't going to grow any more corn on that property to send to the ethanol plant if this would go through. We're worried about liability. If an accident would happen when we're driving our heavy equipment across it, and it's not my heavy equipment, my tenant, we could be liable. We've been told that we can't have, we might not be covered in an accident, and we could lose the farm. It's too big of a risk.
So if you were to turn that into CRP land, you would incur costs associated, I assume, with demolition of that house?
Yes, we would.
And the house, you wouldn't be able to rent it. And I assume that your son is going to be living there very inexpensively?
Do you mean if he would move there?
Yes.
Yeah, yes. Mm-hmm.
So he would incur economic damages as a result of having to live somewhere else?
Absolutely, yes.
You also mentioned that there's a well on the land. Is that well used for the water in the house?
Yes, it is, and we're very concerned about our water. And we learned at the FEMSA meeting that water is very corrosive to these pipelines. When they talked about, there were questions asked if there would be a small leak. And we know that water plus carbon dioxide is carbonic acid, which acidify our well if there would be a small leak, if there would be contamination. And we were also told at that meeting that small leaks are very rare, that normally if a leak is going to happen in a CO2 pipeline, it's under such high pressure that there's more likely going to be a catastrophic event, kind of a zipper-like rupture, where the whole pipeline is just ripped apart like a zipper, and there's a violent explosion, and you can see that in that test rupture. And that's another reason my granddaughter is 13 years old. She saw that test rupture. We showed that to them, and it's very disturbing. I mean, she's very anxious about moving there, and that's part of the reason why they're not moving there. It's just causes a lot of anxiety they don't really need, and it's not right.
Did anyone from Summit ever talk to you about possible steps that could be taken to decrease the potential for problems with your well water?
No.
Objection, Your Honor.
State your objection.
None of these questions are cross-examination. Asking the witness about her son's plans or what she's heard at Board of Supervisors meetings or the well on the property are all things that could easily be included in her 273 pages of testimony and exhibits that are already in evidence. The board's longstanding practice of having direct testimony pre-filed is to eliminate the time spent on direct testimony, and what we're now getting is 2, 3, 4, sometimes up to 6 direct examinations. They're simply not cross-examination questions, and they're improper for this part of the proceeding.
Your Honor, Ms. Glade did specifically mention the well on their property in her direct testimony that was pre-filed. I'm simply asking additional questions about what she mentioned in her direct testimony.
None of which are intended to challenge her testimony or demonstrate her bias in any way. They're all just asking for additional information, which is direct examination, and information that could have been included in the 273 pages already admitted.
So, Ms. Ryan, can we bring it in a little if you can, please?
Well, hold on, for the record, I have to object to that objection. It's certainly not the burden of the landowner to think of everything possible. This would be a 10,000-page pre-filed testimony, and these questions, I think, are going to anything that Ms. Ryan obviously isn't necessarily clear on, or is making her own record, which is completely allowed under the rules.
So, Mr. Jorde, next time you object, please wait for me to recognize you.
Okay.
All right, Ms. Ryan.
I'll move on to a different topic. Also, in your direct testimony, you show that you did a business entity search for Summit Carbon. And I want to make sure I understand. There are two tables there, and if I'm understanding correctly, the top one is from Iowa and the bottom one is from Delaware. That's on page, let me find it, 9 of the direct testimony, if we can pull that up. So the top one is Iowa and the bottom one is Delaware?
Correct.
Okay. Do you feel like this is a complete representation, or are you worried that there are other Summit entities out there that might be related?
Well, we really don't know. I don't believe Summit has been very forthcoming with their investors, with their business entities, and everyone involved. It's been pretty shrouded, I think.
And you indicated in your testimony that you don't know who makes up the entities or what people or governments could be hiding behind them. Why is that a concern?
It's a concern because this easement that they want to take from me, they want to seize my property. We don't know exactly who their investors are, the foreign investors. We don't know who they're going to want to sell this to eventually, whose hands it might end up. And I don't believe that that's right, that they would have foreign investors.
You think that's the kind of information the board should consider in deciding whether or not to issue a permit?
Absolutely, yes.
I think that concludes my questions. Thank you, Ms. Glade.
Thank you.
Mr. Whippel. And just for clarification purposes for all, if we're referencing things in the direct testimony, if we could just please reference the page number or where that's located so we can try to pull it up so people can see it, and also for the record purposes. Mr. Whippel.
Thank you, Your Honor. I want to pull up the KMZ quickly and ask a couple questions about the location of your farm. How far are you from the nearest town?
We are 6 miles south of Clarion.
And is the fire department there volunteer? Do you know?
They're volunteer.
So about how long is the response time?
Well, it depends on how fast they can get in their cars and leave work or whatever, wherever they're at to get to Clarion or to get to the farm. And I understand that they would have limited capabilities as far as self-contained breathing apparatus. The hazmat unit that would respond to a rupture close to our farm would be coming from Fort Dodge. It's at least a 45-minute drive.
And there would be no response from Mason City?
We have been told they'd be coming from Fort Dodge. Fort Dodge, I think, would probably be a little closer.
I also want to understand the location of the proposed route relative to your neighbors. Are there any other nearby neighbors?
Across the road from us, is probably the closest neighbor.
Could we get a distance on that? Can you read that distance for the record?
I can't read it either, so I understand.
1,000?
About 1,000 feet.
Yeah, a little over 1,000 feet. Is that right? Yeah.
So in your testimony at page 38, you talk a little bit about local ordinances and land use regulations. Have you talked to your supervisors in Wright County about a zoning ordinance, or have you attended meetings of supervisors to bring this up?
Yes, I've attended. We've traveled from Cedar Falls to Clarion to those board meetings quite often. We've talked to the board members who are very supportive of the landowners. They've recently passed a drainage district resolution that would afford some protections, I believe, for the farmers in Wright County.
Did you think that drainage district resolution helped protect your land?
I believe it. I don't know the full details of it. I know they tried to have a clause in there that would restrict restrict them from starting to dig to start the project until everything had been resolved in the courts. But that had been taken out. I think some people were there at that meeting. They threatened to sue them for millions to billions of dollars. So they did modify that resolution during that meeting. But I believe there were still some very important protections there. There were no setback limits. We've been asking for setbacks. And I believe they've been unwilling to do that because they're afraid of lawsuits.
Are you saying there was a public threat made of a lawsuit at the supervisor meeting?
Yes.
Is your parcel part of a Wright County drainage district managed by the supervisors?
I'm not sure of that. I don't know.
That's okay. Did you ask the supervisors to pass any other local ordinances?
We have been asking them to do that, to pass ordinances with setbacks. I believe they're afraid to do that.
And have they said why?
Because they're afraid of being sued. I mean, they said it right on the meeting that they would, this could cost the company millions to billions of dollars if they were delayed in starting their project. Wow. And this is, whichever way this is decided here at this meeting, it will be going to the courts, be challenged.
I want to move on from the local zoning for a minute, and it's not moving too far. You talk on page 41 about the least worst location on your property, page 41 of your testimony.
Yes.
Is it easy, staff, to bring up that attachment number 22 and look at it, or would it be simpler just to have her describe where she would prefer the route to be?
We'll go ahead and see if we can pull that out. We have really good staff that does a really good job at this, so.
I notice that daily, Your Honor. Okay, does that look like, can you confirm that that's your least worst route location?
Yes, I can. That we put the least worst, I mean, I don't believe this pipeline project should be approved. There's no reason for this to be approved. There's no public use. Public isn't going to be using this CO2.
I understand.
Yes, if it would go through, we would prefer it to be as far away from our home as possible. And it's at the far edge of our property.
But still on your property, correct?
Correct.
At any point, did you provide this map to Summit and request a route change from the company?
No, I've really not dealt with land agents at all. I have not done any negotiation with them.
So you don't even really know whether a route change on your property would have been acceptable?
No, I don't. I don't believe it would be. I believe the people on either side of us have signed easements. I know they wouldn't be moving it. And they've seen that in the past testimony at this hearing that they're not willing to move.
So the route you propose here, since it's not in the KMZ, it's difficult to gauge distance, but you know your land. Do you know approximately how far that alternate location would be from the house?
I believe that would maybe be closer to a quarter mile or less.
And so you I won't say acceptable to you, but you feel more comfortable at a quarter mile.
It would be better than where I decided now. That's about all I can say.
And did you express a quarter mile to your supervisors in your requests for a zoning ordinance?
No, I would request at least 1,200 feet. I mean, it's, I guess I'm not sure what a quarter mile
Well, we could
is.
do the math on that. I guess, did you express any distance to the supervisor?
Not a specific distance, no, and didn't really get into those kind of details.
At that location, does that put the proposed pipeline closer to any neighbors?
Not that I'm aware of. We don't really have close neighbors to the north of us. There's no one living there for about a mile or more.
So it could be moved, remain on your property, be farther away from your home, and no nearer to any other occupied structures.
Correct. Yes.
Okay, I want to talk a little bit about page 24 of your testimony, where you talk about compensation. So you're, in this passage, if I can paraphrase it, you're talking about alternate forms of payment, regular payments.
Correct.
Did you ever make a specific proposal for alternate compensation?
No.
Would you, what kind of alternate compensation would be the most acceptable to you?
I would think a one-time payment is pretty much a pittance when you compare to what they are going to make from this project. I would expect that we should be compensated yearly, at least at a higher level. I don't know what that would be, but I don't, like I said here, they're making our land a liability rather than an asset, and they need to make up for that fact.
Do you have an amount in mind? You never made a specific
It's
proposal.
really hard to calculate.
It's very hard to calculate.
Yes, it is.
And I know you've expressed resistance to approval of the project, but suppose that it were approved, would there be any conditions the board could impose in the permit that would make you feel more comfortable with the project?
Oh my gosh, there's a lot of things. It should not be a permanent easement. There should be a time limit. These tax credits are temporary. I believe there's just a 12-year taking period. I think an easement after this project is over. The land should just be returned to us. We shouldn't have to worry about a forever easement for a temporary project. And there's probably there are all kinds of things that we could change about the contract. I believe they have such great access as well. I mean, they can have 24/7 access without having to even notify us. I believe there just needs to be some limits to what Summit can do with our land.
And have you watched any of the hearing so far, attended any of it, watched any of the live stream?
Yes, I have.
Was there anything said by any of Summit's witnesses that you would contest or take issue with that you didn't have an opportunity to put in your testimony?
Well, I do. We kind of would like to go on the record as far as Micah Rory's testimony when he talked about the contact list. And this is just another example, I think, of how Summit misrepresents the facts and the truth. We had 26 entries on that contact list, and we can account really for only 7 of those. It said here that they had, on the list, there were 12 phone calls from a Christy Clark. We had 3 voice messages left from her. We never pick up our phone. We don't answer the phone unless we know who's calling. So we depend on just getting those voice messages. We've kept them all. We've kept all of the door tags, the cards left at our door. We've had just 3 land agents come to our door. We had to walk right by our no pipeline signs. And they could tell that we were not interested in negotiating. We also had to put signs up on my mother's door at the nursing home. She lives in a memory unit. We had heard that they had been approaching people in nursing homes with donuts trying to get them to sign. So we had to make up a sign. We had to notify staff at that nursing home to not allow any visitors for my mother unless it was myself or my husband, and if there was anyone else to call us immediately. I don't think we should have had to do that. I think that's just wrong.
Who's the title owner of the property?
My mother was.
But you did receive some phone calls?
I did, yes. Because I was, after my father died, I would have owned a half interest along with my mother, so my name was on the tax.
Okay.
Both.
That's all I have, Your Honor.
Miss Colas.
Good morning, Ms. Glade.
Good morning.
I'm Jean Colas with Colas Family Farms. I have a few questions. Initially, you said you did not negotiate with the Summit representatives, land agents, but they could still continued attempting to talk with you, correct?
They did until I told them that I had retained domino law.
And did they respect? They didn't contact you after that. Did they respect that statement?
Yes, they did. We haven't been contacted since last May.
Okay.
May 22, actually.
Okay.
Over a year.
All right. Also, you mentioned the Sartasia instance, and that's one of the reasons the change in your family plans and your concern about the safety.
Yes.
We had Jack Willingham, who is the Startatia 911 director for Yazoo County, which was where that incident happened. And he was very forthcoming pertaining to the incidents and how they were prepared, lots of things. But one of the things I don't know if you're aware of that he gave in his testimony here was that the danger level of the CO2 in homes there, they were so severe and so high that after the incident was over and they were able to go back into their area, that they could not go into their homes because the CO2 within those homes was so high that it took over 2 hours to clear it out so they could get into those homes. Were you aware of that?
Yes, I was aware of that, and I did attend the 2-day PHMSA meeting in Des Moines, so I saw his testimony at that time too. So it was kind of reinforced by his testimony here.
Great. So to shelter in place is really not the way to go.
No, and
Mr. Leonard,
Objection, Your Honor.
please state your objection.
The last two questions are not cross-examination, they're narratives. For following a question, do you agree with me? The second question, which just wasn't a question at all, it was just a statement.
Ms. Colas, if you could please, or do you have a response?
Well, she brought up Sartasia, and I was trying to clarify just how much information she had. Perhaps I should have worded it differently.
Yeah, if you could word it differently so that it's not inserting an opinion or making a statement, but rather cross-examining the witness based on her testimony, that'd be appreciated. Thank you.
Thank you. I'm not that familiar. Were you aware of the danger of sheltering in place as a result of the CO2 rupture?
yes, I was, because I had heard the testimony of people that lived in a real life situation. They had said it at the PHMSA meeting that if they had sheltered in place, if they hadn't gone in to get those people from the car, they would be dead.
Okay, thank you. I had another question. Can you bring up the evidence, the testimony she had related to all the summit different LLCs that they showed earlier?
I believe that was page 9, Your Honor.
Okay, thank you. So staff can bring up page 9, please.
Okay, I have concern, as I think you do, related to the Summit Carbon Capture Alaska LLC. Is that true?
Yes. Yes, I do.
Were you aware that when I linked Brad Helen's name, the board chair of the IUB, that his name came up as having an affiliation with the Summit,
Mr. Leonard,
Carbon
just hold on a
Capture
second.
LLC?
Mr. Leonard,
Objection to form, not cross-examination. It's a narrative statement. Also, the chair of the Utilities Board is not named Brad. Thank you.
so Ms. Colas,
Sorry.
you had a response?
Well, I don't know how to word it, but
So,
the board chair, Helen,
the board chair, Helen, yep.
I don't know.
So just when you go to ask the question, if you can just reference this that's in the testimony and not insert like I believe or my opinion, but just rather asking the witness the question.
Did you know
Thank you.
that Mr. Helen, board chair, had a prior affiliation with Summit Carbon Capture Alaska LLC?
No, I did not.
No further questions. Thank you.
Oh, thank you. Seeing no other questions, Mr. Jorde, I would return the witness to you for redirect.
No questions from the
We do not know.
Okay, thank you. If we could pull back
Oh, Second. Oh, my apologies. I could not, Mr. Leonard. I didn't. Not that you have to move, but you were blocking my view there of a name placard that was on the end. So, I believe King, correct?
Yes.
Mr. King, if you have a question.
Ms. Glade, is there anything more you'd care to say about negotiations with Summit?
Objection, Your
Mr.
Honor.
Leonard, yes.
Not a cross-examination question, just an invitation for the witness to provide more direct testimony.
And Mr. King, if you've got something that's a question related to the actual testimony versus having her state an opinion, it would be appreciated. Mr. Jorde.
Yep, can we pull the KMZ back up, please? I just wanted, and if we could zoom out a little bit, please. I just want to get a little, and then if you could pull it down. I'm sorry, the other way. There we go. And then zoom out one more, if you wouldn't mind. Okay. Now, ma'am, is it? Does you and your mother or your mom's estate and you own obviously the 3 parcels, and then the 4th parcel by those 3 that isn't shaded in red?
Yes.
And then do you own the 2 parcels to the north of that also?
No.
Okay. I want to get some distances because it wasn't clear. You were asked some questions about a quarter mile and whatnot. If we could go to page 250 of her PDF, her pre-filed testimony, please. 250. Thank you. Okay, so I just want to be clear. This least worst alternative, if there had to be one, you had, I think, mentioned that might be a quarter mile, and I just want to see if we can't pinpoint that for record clarification purposes. I'll just represent you, ma'am, that a quarter mile is 1,320 feet, so 1/4 of 5,280 feet, which is a mile. Are the boxes we see on page 250 of your testimony here that we're looking at, are those roughly 40-acre parcels? Is that your understanding?
Correct, yes.
Okay. And then a 40-acre parcel, are you aware, would be a quarter mile?
Correct.
Or no, let me think about that. No, that wouldn't be a quarter mile. So two of them together would be a quarter mile, right? No, that'd be a half mile. I was right the first time. Okay. So the 40 would be a quarter mile, and I just want to be clear. You can see that there's the Dorla D Hill at the very bottom there, and if we could, or is that all the exhibit? Is that where your house? Oh, thank you. You see the home right there where it says Dorla D Hill.
Right.
Okay, and so that's about a quarter mile that square, and then you own the ground immediately to the north of that, also, right?
Correct.
Okay, so that would be a half mile if we add, from boundary to boundary, correct?
Correct.
And then your proposed route, was it another 40 acres further north, I believe, if we scrolled up? Yeah, there it is. Okay, so again, sorry for all of that, but just getting to the point that the existing home where your son is no longer now going to move if this is approved, would you agree that that's in excess of a quarter mile and probably closer to a half mile from your proposed reroute?
Yes.
Okay. All right. Very good. And then you were asked some questions about setback distances, and you had referenced the number 1,200 feet. But again, I want to be clear, are you looking more for a half mile or more separation from your home based on the risk data you've learned about?
Yes, I would want the pipeline to be just as far away as possible. I mean, a plume could travel more than 1,200 feet. I just would like it as far away from the house as possible.
And did you say that you believe the JDS Farms LLP, your neighbor to the east, had signed an easement?
I believe so, yes.
Okay, and if it was moved further north, it would still be on your land, but it would be on just a different area of the JDS Farms LLP.
Yes.
Okay. The putting in CRP, would that be an economic detriment to you going from CRP to, as opposed to row crop farming?
It would be. The last several years we've gotten very good yields from that field. That's one of our best fields. And our tenant in our agreement will give us a bonus depending on yield and price. And we would be losing that bonus. We would just be getting a set fee for the CRP land. So that would be a loss to us.
But that's a choice you believe you have to make based on all of your concerns about this proposed project?
I believe that would be better than losing the whole farm. We wouldn't be able to get liability if an accident would happen with one of our, with our heavy equipment. Driving over that, if there would be a lawsuit, I think it's worth just not farming in case there would be an accident.
So, perhaps my last question, ma'am. You had stated that you've been listening into this. Obviously, you've been here in person several days as well. Since the filing deadline and since you filed your pre-filed testimony on July 21st, can you, as you sit here today, can you think of any statements Summit has made after that, while under oath here, any of their witnesses that you disagree with? In term, not necessarily philosophically, but just factually, things may be said relative to any experience you have that is not correct.
Well, I don't. When we had our original meeting in Wright County, the public information meeting, they told us at that time that if they did detect a change in pressure in the pipelines, that valves would be shut immediately. They would be shut down, no questions asked. Now, during the testimony here, they testified that they would have to send someone out to determine whether there was a high-risk situation or a low-risk situation. And I think that's just going back on what they had said before. I think that's just them putting their interest above our safety. I don't believe that's something that they misrepresented that at the original meeting, if that's the case, because they're not going to be just shutting the valves down. And we're living in a section that has 20 miles between safety valves. So minutes are going to count here. They don't shut the valves down as they could, rather than sending someone out. I think that's something that I just totally disagree with, and it's not in our best interest. It's in their interests.
So, before you are released, and I just want to make sure, Your Honor, to offer some exhibits that I could frankly offer with anybody, but I would offer Landowners 576 and 577. Those are discovery responses of Summit to landowners.
Any objections to those being entered? Seeing none, we will enter those. Thank you.
All right, thank you. And then one point of clarification, I believe I've already offered, and I think it was received into evidence, LO 577. That's.
I think Summit was still looking.
Oh, I'm
was
sorry.
Still reviewing.
Oh, my apologies.
Mr. Jorde, the versions I'm looking at are completely redacted, or the ones that were uploaded to the system.
Yes, thank you. Summit had designated some of the answers as confidential, so in our abundance of caution, I uploaded, or my staff uploaded those confidentially, Mr. Leonard. So what you're seeing is obviously redacted, the public version.
Thank you for the clarification. No objection to the admission of these documents under confidentiality.
Thank you.
And then,
May I make just one quick request with
That's right,
respect to
yes.
those hearing exhibits? Mr. Jorde, could you circulate the confidential version, or ask Summit to circulate the confidential version to all the parties who have signed the non-disclosure agreement?
yes, I'd be happy to do that. And then I guess I should further say it's my intent to upload versions with all of the non-confidential answers publicly available, but I'll continue to block out anything that's specifically confidential if there's no issue with that.
All right, so to be clear, there are no objections to admitting the redacted version, correct?
Correct.
All right. And Mr. Jorde's agreed to distribute the others to those that can view those documents. All right, thank you.
Yep, and then I'll make another upload just of the non-confidential portions so that those can be publicly available, just those portions. And then lastly, again, to clear up the record here, I think I've previously offered Exhibit 577, which is simply Summit's state overview route map, proposed route map. If I haven't, I'd like to offer that now, 577. Or pardon me, 557.
We are checking on that. We're just going to go ahead and admit it again versus we got a pretty long list of things. So,
I appreciate
any
that.
objections to the admittance of 557? Seeing no objections, that is being admitted.
All right, ma'am. Is there any portion just of the Q&A that you were asked by the other council that you believe is unclear, or are you satisfied with the answers you've given here today?
I'm satisfied with the answers. Yes.
Okay. All right. Well, I don't have anything further for you unless you had any other statements based upon statements that Summit has made since your pre-filed testimony deadline.
Mr. Leonard?
Objection, Your Honor. Twofold. One, I don't believe it's redirect or based on anything that was done in what I'm going to call round two, because I don't believe she was cross-examined by anybody. Secondly, it's asked and answered by Ms. Ryan and already once by Mr. Jorde.
Mr. Jorde?
Well, again, we're dealing with lay witnesses here, probably never even taken the stand before, and I think anything that Summit has said since the deadline for pre-filed testimony is fair game in terms of assertions they've made that landowners have been unable to defend against or speak to.
Mr. Leonard?
Mr. Jorde has asked this exact question a few minutes ago. It was already asked as well by Ms. Ryan. If there was anything said during Summit's testimony, live testimony, after the deadline for her response, or for her pre-filed testimony, it's been asked and answered.
I am going to sustain this objection, and we are going to move on. Thank you.
All right, then I would ask the question, based on any rebuttal testimony that Summit has filed after your ability to file information in this docket, do you have any comments to that?
Same objection, Your
Mr.
Honor.
Leonard?
Same objection, Your Honor. Obviously, the live testimony happened after the rebuttal testimony.
Sure, the rebuttal testimony happened after the landowner's deadline to put in their testimony, so this is the only opportunity to respond to that.
Mr. Leonard?
Yeah, so the pre-filed rebuttal testimony, of course, was filed before the live testimony. This witness has been asked a couple of times if there's anything she's learned since or during the live testimony that she'd like to respond to.
I'm just checking something here quick. So one of the nice things is we do have the stream from the court reporter so we can see things. And your witness, Mr. Jorde, did say that she had nothing further to add. And then he went into another line of questioning. So I think with that, we are done with the witness.
Well, okay. Do you have anything else to add?
Well, I would really like to speak to how I feel the landowners have been silenced in these whole hearings.
Well, is this a good example right now?
And this would be a good example right now, quite proven. People who landowners are unable to virtually testify is wrong. People whose lives are impacted, their land is threatened to be taken away from them. People who live closer to the pipeline than I live are unable to make public comments here or go on the record because no public comments were taken. The whole hearing seemed totally biased to me. From the very first day, we stand in line waiting to get in. No one sees anyone from Summit standing in line. They all get to come in the back door. We're told we can't stand in the back of the room. But on that first day, there were Summit people marching back and forth back there, going behind the black curtain to meet. The landowners were asked for a room to meet with their attorneys here, and they were denied. They said there was no room. But Summit has a room. Summit's security team is working the event, Overwatch. It doesn't take a rocket scientist to see that the optics are not good for landowners in these hearings. They're one-sided. And it's wrong. It's just, I'm being silenced today. I can't say the things that I want to say. I can't say that this whole project is wrong. It's morally wrong. There's no public use. The public is not going to use the carbon dioxide. Summit wants it. They want it to make billions of dollars at our expense and our loss. And this whole process, the whole project is wrong. We've talked to two of our personal lawyers we took our easements to, and they told us there's no reason for you to negotiate. This is wrong. This is not a public utility. This shouldn't even be a thing. And the last 2 years of our lives have been taken from us. We resent the fact that our retirement is lost right now, and we're fighting for our constitutional rights to own property. This is not a public utility. There are no environmental resources, no environmental impact statements are needed when it's coming out about all the water that they're going to need. Billions of gallons, 478 billions of gallons of water is estimated to be used a year for capturing this carbon. And it's our water, it's our land, it's our water. They want to take it, they want us to pay for it with our taxes. And this whole project is based on the 45Q tax credits that are temporary. This is a forever easement they want, based on a very unpredictable source of the 45Q tax credits. This funding from Washington, D.C. could be cut at any time. I mean, I've heard a story this morning about how they're hammering out another budget. This could be in the chopping block. These funds could be gone just like that. And for them to talk about taking our land forever for easements for such a temporary, short-sighted project is wrong.
Thank you. I don't have anything further.
Witness may step down.